We'll bring the meeting to order. Thanks everybody for being here this morning. As we normally do, we'll start off with a moment of silence. Unfortunately, we've lost too many people this year already, so let's have a quick moment to remember those who have paid the ultimate sacrifice. All right, thank you. Okay, we start off the meeting. So we have a quorum this morning. So first item on the agenda is for the minutes from our last meeting.
Mr. Chair, I move we approve the March 28 minutes.
Discussion? All those in favor? Aye. All those opposed?
Aye.
All right, motion passes. And we'll go ahead and move on to our next item. And I'll go ahead and turn it over to you, Steve, being that mostly presentational this morning.
Yes, and by way of introduction, both for this presentation and for the rest, I got a couple of things. One, we're doing something a little bit different than we have in the past. So we'll be giving you today a number of interim presentations. Historically, at the conclusion of that presentation, we've asked you to vote on whether or not you want additional information at a further meeting. We're doing something different, though. This year, we're pulling together all of the we'll do the initial presentations for you at this meeting and the next meeting and the next meeting. And then in July, we'll ask you which out of all of the ones that you've already had initials on you're interested in pursuing further. So we'll talk about that, but there won't be motions concluding the decision on whether to ask for a motion at the conclusion of the initial presentations this morning. The other brief introductory piece is Ryan's doing the first 5 presentations, and his wife's a week overdue for having their first baby. He's got his cell phone in his pocket, and there's a pool on whether or not he makes it through all 5 presentations. So if he suddenly has to depart, that we've planned, Tim's on call to take over, and and if Ryan seems nervous during the presentations, it's not because of the materials or any questions that you're asking. But at this point, then I'll turn it over to Ryan for the first presentation. This is on the issue of definition of child. By way of reminder, this was a topic that came to the board and to the select committee on pension policy at the end of last interim by way of correspondence. And both the select committee and the Left 2 board approached it the same way. It came up too late to really work on it last interim, but it was going to be something that you would learn more about this interim. And with that, I'll turn it over to Ryan.
Thanks, Steve. Members of the board, for the record, Ryan Frost, Research and Policy Manager. And this is, as Steve mentioned, the definition of child. So the issue before you is that the left definition of child excludes children adopted after retirement from eligibility for benefits. LEF provides benefits to children of active and retired members. LEF Plan 1 and Plan 2 provide different benefits, but they both use the same definition of child. While the definition includes children adopted before retirement, it excludes children adopted after retirement. As Steve mentioned, this issue has been discussed by the LEF Plan 2 board twice. The member correspondence was presented on this topic during the board's administrative update at the November 2017 meeting. The board directed staff to present a comprehensive report at the next meeting, and at the December 20th meeting, a motion was passed to not take any action on the issue. The Select Committee on Pension Policy heard testimony and conducted a work session on this issue at their December 2017 meeting, but while some members expressed interest in the issue, no action was ultimately taken. So the left definition of child, as I mentioned, includes children adopted before retirement. Child or children means an unmarried person who is under the age of 18 and who is a natural-born child or a stepchild where that relationship was in existence prior to the date benefits are payable under this chapter, or a posthumous child, or a child legally adopted or made a legal ward of a member prior to the date benefits are payable, or an illegitimate child legitimized prior to the date any benefits are payable. And workers' compensation law also has a similar provision as the LEF statutes. And this creates two categories of children. One, biological children who qualify by the circumstances of their birth, and two, stepchildren, adopted children, or illegitimate children who do not qualify unless they satisfy a statutory condition, for example, adoption, before the member retires. Now, while there is no specific statutory history, this provision may have been enacted out of concern that a beneficiary might adopt a child after retirement to enhance benefits. This same policy is found in the Left Plan 1 surviving spouse benefit, which only allows benefits to a spouse married to the member for at least 1 year prior to retirement. Go over a bit of the benefits for each plan. Both Left Plan 1 and Plan 2 provide benefits to qualifying children. For Left Plan 2, a death and service benefit with a choice between retirement allowance, which goes directly to the child if there is no surviving spouse, or is derived from a surviving spouse if he or she dies after the member, but the child is still under the age of majority, or 150% contribution refund if there is no surviving spouse. For the duty death benefit, there's an unreduced survivor allowance if there is no surviving spouse. There's a reimbursement of health insurance premiums, and there's also the tuition waiver. For a catastrophic disability benefit, there's, again, the reimbursement of health insurance premiums and the tuition waiver. And lastly, the survivor may establish service credit for interruptive military service credit if the member died before establishing their leave.
Are there any questions about any of those? Those are the left two benefits for which a child could potentially qualify. Are there any questions about any of those?
Okay. For Left Plan 1, Left 1 actually increases the benefits of retirees and surviving spouses with qualifying children. For the duty disability, you gain an additional 5% of your final average salary for each child, up to a maximum of 10%. So a maximum of two children would qualify for that. And then a death benefit, whether it's duty or non-duty, the surviving spouse would receive an additional 5% of their final average salary for each child, up to a maximum of 10% again. If there's no surviving spouse, or their surviving spouse dies with qualifying children, the children receive 30% of the final average salary for one child, with 10% for each additional child, up to 60%. Share and share alike, which means they would split it evenly among themselves. If there's 4 children, for the 60%, they would each get 15% of the benefit. Questions about that? As Steve mentioned, the member correspondence was sent to the Left 2 board by the widow of a Left Plan 1 disability retiree who adopted children after retirement. She argues that the exclusion of the children is discriminatory and is seeking legislation to include children adopted after the date of retirement within the left definition of child. And with that, I'd be happy to answer any questions.
One quick update on that as well. The Select Committee on Pension Policy met earlier this month and asked for a briefing on issues that were possibilities that the Left Board could be working on this interim where there might be coordination. This was one of the issues I identified for them. They were familiar with it as well because they had the correspondence at the end of last year as well. One background change in the background, the widow who wrote the correspondence to the SCPP and to the Left 2 board has filed suit against DRS on the discrimination issue that Ryan mentioned. And so there may be, in the past, that's played out a couple of different ways. We'll talk more about it in July. terms of, do you wait for the court to resolve the issue, or do you move forward regardless of the court cases? And that's come up. The SCPP will be kind of considering the same issue. And by reminder as well, the author of the correspondence was the widow of a Left One retiree. Any questions for Ryan before we move on to the next one? Mike?
Thank you, Steve. Just clarifying, this is a issue that's unique to LEF, or does it affect all pension plans?
The definition of child is different for each plan, but this one is unique to LEF.
Is it possible to see what the others? Yeah, thanks.
All right. You made it through one without the phone going off.
Maybe
So,
I just didn't hear it. You might be getting the
I'm
call
not sure
here soon.
who's already lost out on the pool, but we'll keep moving forward. The second issue, by way of reference, was another issue that came up late last year. There was an initial presentation on the board last year, and then you decided not to move forward with anything beyond that and to come back at it this interim. The title has changed slightly as the understanding of the issue has also grown. I think last year we called it out of state duty or something along those lines, but now we realize a lot of those same issues can apply in state if you happen to be out of your jurisdiction, particularly for firefighters. And with that, though, I'll turn it over to Ryan.
Thanks, Steve. Again, Ryan Frost, Research and Policy Manager, and this is out of jurisdiction duty. The issue before the board is that members who are injured while responding to an emergency out of their jurisdiction are not entitled to left to duty disability or duty death benefits. By way of background, an off-duty member who becomes disabled or is killed while responding to a mass casualty incident has the same level of benefits as a member who becomes disabled or is killed from any other type of non-duty occurrence. There's been a recent push across the West Coast in response to last year's Las Vegas terrorist attack to ensure that first responders receive duty-related benefits when responding to an incident, no matter where it takes place. As I mentioned about the Las Vegas terrorist attack, there was a number of California law enforcement officers who were shot and injured while providing life-saving care at the venue. But when they went to file workers' compensation claims for time that they had to miss due to being shot, they were denied. Had those off-duty officers been shot and injured while responding to an incident in California, they likely would have received benefits without dispute. But because they were injured in Nevada, their efforts could cost them pretty dearly. As I mentioned in my interim preview, there was legislation that has been introduced in California to give these members access to workers' compensation benefits, but that bill ultimately didn't go anywhere this session. So happens next year with it down there. For current left benefits, current statute limits duty, disability, retirement, and duty-related death benefits to members who become injured while on the clock with their employers. Any member who becomes disabled during their off time is limited to a non-duty disability benefit. That calculation for the non-duty disability benefit is 2% times their final average salary times their service credit years, and that monthly benefit is then reduced to reflect the difference between the member's age at the time of their disability retirement and age 53. Suffering a disability at a younger age will therefore lead to a larger reduction. The survivors of any member who is killed during their off time are limited to either a withdrawal of member contributions if they have less than 10 years of service, or a non-duty death benefit. The calculation for that non-duty death benefit is reduced in the same manner as the non-duty disability benefit. Many of the opponents down in California to that bill argued that members coverage for these types of events should be done at the federal level. The most common federal benefit for public safety officers who are killed or become catastrophically disabled is the Public Safety Officers Benefits Program. That program provides a $343,589 lump sum payment for death and total disability benefits for eligible public safety officers. That definition of eligibility states that a public safety officer's death or total and permanent disability must result from injuries sustained in the line of duty. And line of duty means any action that the officer is authorized or obligated to perform by law, rule, regulation, or condition of employment or service, and therefore that benefit does not apply either to out of jurisdiction disabilities or deaths. Any questions so far? So that really brings us to the primary policy question of whether the board wants to consider expanding death and disability coverage for these types of events. The current benefit, as I mentioned, for these members only provides the normal retirement formula reduced by the difference between the member's age and age 53. Some questions that can be further explored are: should the level of benefits rise to the level of a line of duty disability death providing full earned benefits? If a member becomes catastrophically disabled, should the level of benefits rise to the catastrophic duty disability benefit, or a member would receive 70% of their final average salary, as well as a medical premium reimbursements? If a member dies while performing this type of service, should his survivor be entitled to the lump sum payment of 150% of their contributions plus interest, or a monthly benefit? If a member dies while performing this type of service, should his survivor be entitled to the lump sum line of duty death benefit? And lastly, if a member dies while performing this type of service, should the level of benefits include medical premium reimbursements provided to survivors of a member killed in the course of employment? This issue of compensation is certain to remain on the forefront as communities across the country face threats from those types of events and the threats of wildfires that have particularly struck in Washington. With that, I would be happy to answer any questions.
One of the things that we learned following the discussion that the board had last session, and again, we're not expecting you guys to answer those policy questions or talk about those today. There's no action required today. This is just a reminder of what this issue is and the types of things that if you decide in July to push it forward, that'll be issues that you'll have to resolve. But the train derailment, that for some of the emergency responders was, if you happen to be driving along I-5 that morning and you were responding to what was happening in front of you, you may have been doing it at your own risk. There were left two members from Washington State at the concert in Las Vegas. Fortunately, none of them were injured in the line of duty, so Washington State didn't have to face the same types of questions about that California is, in terms of what are the expectations for emergency first responders in those types of emergencies. If the expectation for the public or for the employers is, yeah, you need to help out, then doing it at their own risk is not appropriate. And it's the same thing if that happens in Washington. You don't want to put a left two member or their family in that terrible situation where they're expected to put themselves at personal risk and there's no safety net for them, which, or that to the extent that there is a safety net, it's dramatically different from the rest of the emergency response that they do in their jurisdiction or while they're on the clock. For law enforcement officers, your jurisdiction can be the whole state, depending on the agreements that are reached and the types of things that you're responding to. And there are procedures for calling in and letting the local police officers know that you're there and what's going on. For firefighters, it's not quite the same. And that would be one of the things that we'd be looking at and talking about later on this interim. So, again, it hasn't happened yet in Washington, but it's just pure chance that it hasn't happened yet. Ryan mentioned the wildfires. There are a number of Washington firefighters who have responded to those. That's more of a voluntary thing. I don't know if the policy issues are different on those, but that again would be one of the issues to discuss in the future. But are there any specific questions for Ryan, or any specific issues that you're aware of that you want to make sure he's got on his radar as he prepares for this? Jason?
Steve?
Yeah, thanks, Ryan. The members who are injured while responding to emergency out of their jurisdiction. So, as law enforcement officer, I have sworn law enforcement powers throughout the entire state of Washington. So, if I was acting, let's say, in some type of capacity, which is pretty common, I could be in Pierce County doing an interview at the jail. Is that out of my jurisdiction, or are we talking out of jurisdiction being out of state?
We're talking more out of jurisdiction and off duty, and,
Okay.
and volunteering to respond to an incident on your own accord, not placed there by your employer.
Okay, so off duty in Pierce County, would that be out of jurisdiction?
In this case, yeah.
Thank you.
It's the kind of thing that could differ from employer to employer in terms of, so for instance, if you were driving back, you're off the clock, if you will, after being up in Pierce County, and suddenly there's an incident on I-5 and a shooting, and active shooter or something like that, your employer may or may not have policies that kind of tell you what you can and can't do in that situation. If you respond, call 911 and let them know that you're responding and that you're in plain clothes or whatever, or don't respond if you're off duty. That's at least from initial experience, that's what we're finding. Law enforcement officers, your coverage seems to be much broader, or your options appear to be broader than firefighters. If you were a firefighter from Skagit County and you happen to be on I-5 the morning of the train derailment, there's no possibility of contacting your employer to say, what do you want me to do? They have to kind of make that call individually. But that's the type of thing we'll dig into and get a little bit more data on, trying to understand a lot of those differences between police and fire, and even within fire, perhaps.
Steve?
Yes, Ade?
Yeah, I guess I need a little bit of education on this. But what about either a police officer or even a firefighter, after putting in maybe 12, 15 hours of work, or maybe on holiday, few bottles of beer, and where their decision skill may be impaired?
Yeah.
And of course, you see this terrible thing happening. You want to help as human being, knowing that you have the skill. By the same token, because of being tired or a little bit, one glass too many may actually impair their judgment. Doesn't that also put the officer at risk that may actually I mean, so without somebody saying, okay, fine, go do it or don't do it, isn't that a little bit risky? I don't know how,
No,
a firefighter, how to handle this kind of condition of firefighter, but I think it just can be a little bit, because their position, they have to be able to respond within seconds to things. They're not accountants like some of us that, but when your thinking processing is impaired, your response time also is impaired. So would these people be more at risk just reacting to wanting to save somebody, and they may not really be in a position to do that?
That's a fair question, Ade. It's one that a lot of jurisdictions have confronted when they're considering this kind of thing. So, for instance, whether you're off-duty police officer or off-duty firefighter, you may not have your equipment. You may have some gear in the trunk of your car if you're a law enforcement officer that you can get to quickly, but you may not. Firefighters, if they're off-duty, very rarely have access to any of their protective gear. The question about should the expectations for a person to respond be different if they are impaired by either long hours or alcohol or something else, that's come up a number of different times. There's been cases of people responding, for instance, to a fire and they don't have the gear and they've had a couple of beers and then their response doesn't go well. And then the question is, should they have ever tried to respond in the first place? It is a difficult situation, difficult analysis for a person to make in seconds, like you said, Ade. But that is clearly one of the issues that would have to be considered related to providing coverage in these types of situations. What are the expectations for people, and are those expectations different in different circumstances, like you mentioned?
Well, thank you, Mr. Chair. I think some of the discussion here is going to the other side of the issue. We're talking about whether or not the authority or the skill set should be applied, and that's a completely separate issue from setting a bright line as to when, if and when we'll provide benefits under the system here. I anticipate, as with many things that we run into, that there's different skill sets or different applications out there between fire and police. We'll probably end up having different standards here. Ryan, if you'll check, ever since the early 1980s, probably farther back than that, WASPIC has had a registry about every 4 years here to where they actually have a mutual agreement that about 90 to 95% of the jurisdictions in the state sign on to that provide mutual primary jurisdiction throughout the state. That being the case, we're going to have a trigger event or decision-making process, declaration, or a policy out there that's going to have to be established to tell us when, in fact, the authority kicks in. And unlike fire, yes, you do the job, but when you're off duty, you don't have an obligation, so to speak, to react. Although as an EMT or a paramedic kind of thing, you probably end up having a protective aspect if you do respond. Police, the commission's 24/7, whether you're on duty or off duty out there. So if we're talking about the appropriateness or the capacity of the officer to initiate or involve themselves, that's the other side of the equation here. This is simply about setting some bright lines. And like I said, I think we're going to have different standards out there for cops and fire when this in fact will take place. And I think part of that's going to be because of the nature of a 24/7 commission and the option to insert expectation at times. Some departments actually expect that you'll carry off duty, this kind of thing. You see something that is as an active situation that you will assist other officers, you will involve yourself. Some of the specific agencies outside of this agreement have mutual aid packs out there for immediate backup. So I mean, they're totally different animals here, but we need to figure out what the standards are out there probably at the state level, State Fire Council or the equivalent, and WASPIC, I would guess, would be more of an appropriate choice than WACOPS would be in this matter.
I'd just like to add one thing that was sort of triggered by this discussion, if you will, and that was sort of the risk to the officer or the responder, and that is that it's toward Jordan, by the way, with the AG's office, and that is that Washington has a very strong Good Samaritan law, which basically protects every person who is rendering volunteer emergency or medical services in the case of any event. But that law only protects people who are responding without compensation or the expectation of compensation. So there might be an interaction between the Good Samaritan law and now this proposal that's worth looking at by virtue of the fact that if there is an expectation of a different level of compensation by virtue of a proposed disability benefit, then that might change expectations vis-a-vis the Good Samaritan law. And I don't have an answer to that now, but it's like Representative Holy just brought up. It's very important, I think, to sort of look at all the various pieces of this. And I just mentioned that because people talked about the risk earlier to an individual person responding. And as long as you're doing so in an emergency capacity, I guess I would just say without expectation of compensation, I would say just remind everyone that this Good Samaritan law gives everyone a shield as long as you're doing so out of the good graces of, voluntarily, so to speak. So.
Any other questions for Ryan?
Yeah, Steve. The only other thing I think I would add or maybe question is what are the standards for someone, using California as an example that has this system in place? What are the standards for, proof showing that you were actually doing your job or working towards that? It'd be very tragic that, say, at a mass shooting, you're the first person that's gunned down, but how do you prove that either you were the first person that was gunned down and not deserving of benefits versus someone who stuck around, was there doing their job, helping, saving lives. So yeah, I guess that'd be the question.
Okay.
Especially, there may be circumstances where nobody will ever know who was there doing what because everybody ends up dying. That's happened as well. So that's a good point, Mike. We'll make sure that we research that as well. All right, that's two presentations. Somebody else is out of the pool. We'll move on to number 3. This was an issue that was brought to the attention of the Left 2 board last year during meetings we had with the Department of Retirement Systems related to the duty disability rules. And at the last year, the board elected to defer further consideration of this issue until this interim. So Ryan, I'll turn it over to you to remind the board of what this issue is all about.
Okay. Thanks. For the record, Ryan Frost, Research and Policy Manager. This is Disabled Members Return to Work. The issue before you is that the disability benefits for members who recover from their disabilities are ambiguous if their previous employer refuses to hire them back. As Steve mentioned, this issue arose from working with DRS on the duty disability rulemaking project. Current disability statute for Left Plan 2 provides that when a member is determined to have recovered from a disability and is no longer entitled to workers' compensation benefits, the member's previous employer is required to hire them back at their previous rank and or pay. Once back in service, the member begins earning service credit again and becomes eligible for an active member benefit. However, issues arise when the employer disagrees with the DRS decision that the member has fully recovered from that disability. This leaves the member in an ambiguous circumstance pending the appeals decision because 1, their disability payments have been stopped, and 2, they're not earning a salary because their former employer will not hire as I mentioned, the disability payments being stopped. Any member who receives a disability allowance is subject to independent medical examinations as required by DRS. If that medical examination reveals that the member has recovered from their disability, they're no longer entitled to disability benefits. The member's disability retirement allowance is therefore canceled, and the member shall be restored to duty. Once that determination has been made that they're recovered, the member's previous employer is required to hire them back at the same civil service rank they held at the time of their disability retirement. The employer may appeal if they disagree with that determination. Following cancellation of the member's disability benefit and upon their return to a life-eligible position, again, they will begin earning service credit and become eligible for that active member benefit. So as soon as DRS determines the member is no longer disabled, all the pension statutes are written to terminate the member's disability benefit. However, sometimes there are two parties trying to decide whether the member is disabled, DRS and the previous employer. These parties have a differing opinion about whether the member is actually recovered from their disability. Therefore, the member is caught in limbo. It could be a good faith disagreement between the two parties on the member's level of recovery, or it could be that the employer does not want to hire this member back, so they use the appeals process to delay their rehiring as long as possible. At the time Steve mentioned we were doing our rulemaking, DRS was aware of one current case where they made the determination that the member was recovered from their disability, but that member's employer refused to hire them back. DRS made the decision to continue to pay that member's disability benefit while he worked his way through the appeals process, rather than leave him with nothing. That case ultimately was settled out of court, and the individual remained as a disability retiree. Any questions so far? Okay. For policy considerations, as I mentioned, for that current case, the DRS continued to pay the member's disability benefit. Those benefits were paid for by the fund, which means all the other members, employers, and the state were paying for those extra disability benefits that were made while it worked its way through the appeal. So that leads us to a few questions. If DRS determines the member has recovered, what do they do in the situation where the employer disagrees? Is the board comfortable with a member still being paid a disability benefit even if they're no longer disabled? If the determination is upheld during that appeals process, who should pay for those extra disability payments that were made? And lastly, who should, kind of in the same vein, who should foot the bill for those extra disability payments? Should it be the trust fund? Should it be the employer who disagreed with the decision? So those are some policy questions that will come up and be answered throughout the course of this study. That I'd be happy to answer any questions.
Jason?
Thank you, Steve. Ryan, is there a mechanism that is currently in place where DRS would be able to seek remuneration from an employer in this instance, or vice versa?
Not that I'm aware of, no.
Tor, are you aware of any mechanism?
I'm not aware of it. Doesn't mean it doesn't exist, but I don't know. So.
Okay. Thank you.
You can get somebody from DRS maybe at the next one to answer that question.
Well, totally on another subject, I'm kind of curious. Has anybody offered to split the pool proceeds with you here if you leave on their square?
Not with me. I don't know who's been talking to Maria,
Ryan,
but
he comes across as such a friendly guy too, but I got here early this morning. He was already here at 7:30, and he had considered sending a text message out telling Tim, "Hey, I couldn't make it. I'm headed to the hospital," and just to mess with him. But Tim was driving at the time, and so he thought he thoughtfully held off on that little practical joke, but he was totally thinking about it. So, yeah. And are there any other questions on this issue before Mark?
Just wondering if there is a mechanism in the rulemaking process to put something in place that would forestall this from happening in the future. I don't know. I mean, would it have to be a statutory change, or could there be a rule
Well,
directing the parties or enabling some kind of mechanism to
because
solve
this
that?
came up in discussions with DRS during the disability rulemaking process, that was one of the questions that was considered. Is this something that could be dealt with by rule? At that time, the opinion of the department was, no, the statutes are actually fairly clear on this. And so it's, DRS, I think, was within their authority to say, when there are disputing doctors, that it's okay to consider the question of whether or not a member's fully recovered from their disability as still somewhat in doubt, even though the DRS medical examiners have determined that, no, they've recovered. But that, even going that far was something where they felt like this statutory change would help that, and that it would require a statutory change. I don't know who would sue in those types of cases where DRS was continuing to pay the benefits in this. It would probably have to be like another plan member alleging some harm to the fund. Or well, I think what DRS was worried is, what if there's some kind of audit, and would a audit finding then put this member's benefit payments in some kind of jeopardy? So the solution that was the path forward that was kind of determined as we were going through is this was just one of the spin-outs that would probably require legislative change. It could come from the board, it could come from DRS, could be a joint project. That part, we never got that far down the road because, again, that was not on the board's legislative agenda for last session. But those would be questions to work out with the department moving forward for next session if this is an issue you decide to move forward on. Okay, 3 presentations. Somebody else is out. The next item, this was the second issue that came out of the discussions with DRS on the duty disability rulemaking last year. Again, you had presentations on this topic the last interim and decided to defer action until this interim, so this is a kind of a reminder. With that, I'll turn it over to Ryan to talk about it further.
Thanks, Steve. Again, Ryan Frost, Research and Policy Manager, and this is PEB coverage for catastrophic retirees. The issue before the board, left point 2, catastrophic disability retirees and their survivors have different medical insurance access than survivors of members killed in the line of duty. More specifically, they do not have access to PEB coverage. So legislation enacted in 2001 enabled surviving spouses of emergency service personnel killed in the line of duty on or after January 1st, 1998 to purchase health care benefits from the Public Employee Benefits Board. Emergency service personnel for this purpose included firefighters and law enforcement officers of the LEF system, as well as volunteer firefighters and reserve officers, the relief and pension system. Under that 2001 legislation, the cost of the insurance was paid by their surviving spouses and the dependent children. 5 years later, a bill passed in 2006, which allowed the retirement allowance paid to survivors of all left 2 members killed in the course of employment to be reimbursed for the cost of participating in a PEB health insurance plan. Survivors of members killed in the line of duty prior to 98, as well as on or after 98, are eligible to participate in the PEB health insurance plans under this 2006 bill. And participation in the PEB benefit system has 2 main advantages. One, You pay the same rate as the entire PEB pool, which is much lower than going out and getting private coverage. And the second is that PEB pays Medicare Part B premiums for Medicare-covered retirees. Left Point 2, however, does not provide access to any health care insurance for any disability retirees. A disability retiree may have access to health care insurance through their employer or employee associations or through the open market. Catastrophic disability retirees and survivors do not have access to benefits through PEB unless they are already receiving PEB benefits through their employer. This means these members are receiving benefits through COBRA coverage, which usually lasts up to 18 months after separation, through coverage offered to retirees through their employer, which is not common, or individual coverage from the open market. As I mentioned, shopping for private coverage can be challenging and expensive, and for DRS, tracking and paying a diverse and shifting field of these individual providers has created administrative challenges. As far as costs, retiree medical premiums for an individual and spouse in PEB in 2017 were $1,243. Private coverage through the state's benefit exchange on average costs about $1,600. Since 2010, Left Point 2 has provided a reimbursement to the disability allowance of a Left Point 2 member that is totally disabled in the line of duty. That includes reimbursement for any payments made for employer-provided medical insurance. This includes medical insurance offered under COBRA and Medicare Parts A and B. The reimbursement is capped at the former employer's current COBRA amount or other employer-provided retiree medical insurance premium amount. Bit of history. During the 2008 interim, the board studied options for extending the healthcare premium assistance to catastrophic retirees and their survivors. At the board's request, the legislature introduced House Bill 1679 in 2009. That 2009 bill proposed including catastrophically disabled Left Point 2 members, their spouses, and dependent children in that PEB risk pool, with the individuals paying their own PEB premium until they were Medicare eligible. The Healthcare Authority had a fiscal note attached to that bill, which estimated a total cost of $1.5 million the first biennium, ramping up to $4.7 million by the 2013-2015 biennium. That fiscal note assumed, among other things, 14 new catastrophic retirees added on January 1st of each year. And ultimately, the 2009 version of that bill failed due to that fiscal note. The following year, the legislature substituted a new bill containing the provisions now found in law, where it did not expand PEB participation, but it did authorize the Left Trust Fund to reimburse catastrophic retirees and their survivors for health insurance premiums up to the authorized COBRA levels. As I mentioned about the fiscal note, experience may lower cost of the board's original PEB proposal. Writing a fiscal note requires predicting the future. Sometimes actual experience does not track those predictions. The Healthcare Authority's fiscal note assumed a higher rate of catastrophic retirements than current experience demonstrates. The Actuary's Office has completed 2 experience studies since that time, showing a significantly lower catastrophic retirement rate of 4.5 a year. The OSA's sensitivity analysis in that 2009 bill found that cutting the estimated number of retirees, catastrophic retirees in half, reduced the estimated cost by half. So given that analysis, the lower rate of actual catastrophic retirements indicates a significantly lower cost than estimated in that original fiscal note to include these catastrophic members in PEB. So that brings us to policy considerations. Does the board want to, again, look at expanding PEB coverage to catastrophic retirees and survivors? Do they want to cover covered benefits to include reimbursement for Medicare Part C and D premiums? Again, Part D is prescription drug coverage, Part B is medical insurance, and Part A is the hospital insurance. And with that, I'd be happy to answer any questions.
Questions for Ryan?
Thank you. So when the Healthcare Authority does a cost analysis, who do they use to, they have in-house actuaries? Do they use the Office of the State Actuary? Do they go outside and use a private firm?
I believe they use their own.
They relied in part on some of the assumptions of the Office of the Actuary, and then the PEB stuff is their own as well. And at times they contract with actuaries. I don't recall that they did that on that particular fiscal note. I believe they used some of the assumptions from OSA and then their own kind of cost calculations. There were certainly some assumptions that were done in-house from working with them on that fiscal note extensively during that interim. And that would probably be one of the things that would, if you decided to move forward on that, that would be a major area of coordination with HCA to figure out what assumptions they would be using for their new fiscal note and why, to get a feel for how different the expected costs to the fund would be. That was a big question. The other question, though, that's come up is this issue of consistency. Should the benefits be consistent with what's provided to survivors when there's a line of duty death or not? And should it be consistent among the catastrophic survivors? Right now, they get reimbursed for whatever coverage they can find on the private market, and that could be very different depending on whether you're in King County or Mason County, for instance. And should that make a difference? Is that consistency, statewide consistency, how important is that issue? Those would be the things that you would be dealing with on that topic if you choose to pursue this one.
One other piece of that is the catastrophic disability benefit was rather new at that time, and we've had 10 extra years of experience to see some experience play out, and so.
So just a comment, then those are two of my big concerns would be the consistency issue and also to make sure that the healthcare authority that they use the best possible information and the best educated people. I don't know if they have some guy in the back room at the healthcare authority who's making some of these decisions, or do they really need to, that would be a concern of mine, or do they have somebody who is an actual actuary who's doing that?
Yeah, Jason?
Thanks for the presentation, Ryan. Question on the HCA study. Does that study include the Medicare component for A through D?
The
Or did
fiscal
they-
note?
Yes.
I have to go back through, but I think it was just, the cost was just to reimburse members going into PEB and how much they expected that to cost.
Thank you. Thanks, Steve.
But PEB does cover Medicare A and B, so
Yeah.
Back
So
door,
did-
yeah.
And so does catastrophic. All right. 4 down,
Yeah.
1 to go. Did you check to make sure your phone was on?
no.
Oh.
Yep.
All right. Ryan's fifth presentation is also a topic that's been discussed by the board in the past, dealing with standby pay. And last interim, you deferred discussion of this topic further until this interim, so we're bringing it back as a reminder of what the issue is and sort of where it stands. And with that, I will turn it over to you, Ryan.
Steve, again, for the record, Ryan Frost, Research and Policy Manager, and this is standby pay as basic salary. The issue before the board is standby pay is not part of basic salary, also called reportable compensation. I'll get into that a little bit later, the difference between the two, used in computing Left Plan 2 contributions and pensions. So a majority of law enforcement officers and firefighters do not receive standby pay. Instead, they are generally subject to call-up if an emergency requires more resources than available from on-duty staff. However, some Left Plan 2 members receive standby pay while off-duty in exchange for being prepared to work on short notice. This payment is not considered compensation for services rendered and generally is not reportable compensation for Left 2. The board, as Steve mentioned, the board considered this issue 2 years ago, actually, during the 2016 interim. An initial consideration report was provided to the board at the September 2016 meeting, but the board did not take any further action on this issue at that time. Standby pay is reportable compensation, however, for pension purposes in two state retirement systems: the Public Employees Retirement System and the Public Safety Employees Retirement System. In 1994, legislation was enacted that allowed the inclusion of standby pay in compensation earnable for PERS when 1, the member is required to be present at or in the immediate vicinity of a specified location, and 2, the employer requires the member to be prepared to work immediately for work if the need arises. In 1995, the requirement that the member be present or in the immediate vicinity was dropped. Standby pay was included as compensation earnable for PSERS when PSERS was created in 2003. Reportable compensation is used in determining a state retirement system member's pension. DRS uses this term universally for all plans, regardless of terminology in RCW. It's generally defined as salaries and wages payable for services rendered to the employer. DRS determines reportable compensation based upon the nature of the payment made to an employee, not the name given to it. In order for a LEF member's salary or wages to be subject to retirement system contributions and included in the calculation of his or her retirement benefit, they must meet the definition of basic salary in LEF retirement law. As far as basic salary, in LEF 2, reportable compensation is termed basic salary. So they mean the same thing, even though it's stated as reportable compensation in the DRS. Under the LEF 2, it's termed basic salary. In order for compensation to be reportable to DRS for LEF, it must be basic salary. Basic salary is the same as reportable compensation. It's a payment that is a salary or wage earned during a calendar month for personal services rendered by a member to an employer. Certain payments that are not for personal services rendered by a member also qualify if there are specific provisions in the laws identifying them as basic salary. I'll go into those a little bit later. It's on an employer-to-employer basis. But payments not specifically identified in the rules qualify as basic salary only if the payments are for services rendered. Standby pay is one such payment that does not qualify as basic salary for LEF, as again, it is not considered pay for services rendered, and therefore is not considered basic salary. So what is standby pay? Standby pay is usually a nominal rate of pay provided in exchange for the employee being available to come to work quickly if they're called on, though he or she might not ever be called. While on standby, an employee is usually confined to a specific geographic area, and they're prohibited from consuming alcohol or other intoxicants. If the employee is called in, he or she usually earns overtime for any periods actually worked. As I mentioned before, DRS excludes standby pay from LEF basic salary because they do not consider it service rendered. While ready to work if called, an employee on standby is engaged in personal activities, not actually performing work for their employer. During the 2016 interim, there was an informal survey sent out, which identified the following examples of standby pay for LEF members. The arrangements vary depending upon the local collective bargaining agreement. For firefighters, some examples were a position assigned to work 8-hour shift may be required to muster after hours, which included the fire investigators, fire marshals, or public information officers, battalion chiefs, and or deputy chiefs. A station that combines career and volunteer firefighters may have a career firefighter on standby to respond to a fire call to aid the volunteers. Another example was a lieutenant may be designated to respond to an incident in place of a chief's and would earn standby pay the same as the chief would. And then there was at least one jurisdiction that paid standby pay to crews in fire camps while working on state mobilizations. On the law enforcement side, the only example found was law enforcement officers on special squads, such as detectives, sometimes earn pay for being on standby. The rate of standby pay varied in that survey, but it's usually, as I mentioned, in the form of a reduced rate of compensation Some of the firefighter examples were a reduced rate of pay. Some jurisdictions paid an hourly standby wage at a reduced rate of pay, such as 10% of regular pay, or reduced hours. Some jurisdictions paid a full overtime wage for a reduced number of hours. One employer paid 1 hour of overtime for a 12-hour standby shift. On the law enforcement side, one example was a 4 hours pay for being on standby and additional pay if called in for more than 4 hours. The other example was there's no standby pay, but you're guaranteed a 4-hour pay minimum if you were called in. As I mentioned a few slides ago, whether an employee's standby pay is reportable can entirely depend on the employer's payroll and personnel classifications. If a jurisdiction tracks standby pay as a separate type of pay, it is not reported to LEF. But if the pay is paid as overtime or straight time for a reduced number of hours, that amount would be coded as reportable pay and reported to DRS, where the member would pay contributions on it and earn service credit for it. With that, be happy to answer any questions.
Well, thank you, Mr. Chair. Ryan, this is for both you and Steve. I want to go back a little bit on this. This topic's been around for a long time. We've even addressed this in the course of collective bargaining, tried to figure out if there's ways around this. I noticed that the foundation for this definition are WACs, which is not a statutory authority. It's a policy that's asserted or set when you actually have the lack of statutory definition, or something's obscure, it's off point, something like that, or you need more details. So they'll establish this as a matter of situational interpretation, relative to who the director of the agency is at the time. Steve or Ryan, can you go back and tell us how long this has been in place, and if this is something that was a definition that was put in place, or a policy that was put in place before standby pay became what it is today? In other words, you limit geographic, alcohol consumption, social activities are limited, response time is this, gear you have to have with you is this. And the reason I'm asking this is that it might be a perceptual differentiation between that and sitting in a fire station, waiting for the bell to ring, or driving aimlessly about with no intended destination for no apparent reason on patrol. I mean, you're not providing a specific service at the time, although you're poised and ready to go as a service. Chris, I mean, I'm trying to figure out what the foundation for this is, and can this be changed by rulemaking? Are they resistant to it? Do they need a statutory definition?
The rule defining what types of compensation for all the plans was reviewed by DRS a long time ago. Paul Neal did it, I think, when he was the legal services manager over there over 20-some years ago. And so historically, the time frame goes way back. Standby pay certainly has changed, and the reason it was done in rule is this question about, is that a service rendered or not when you're on standby? The statute just says services rendered, and so the department was stepping in to say, in this case, that does not rise to the level of service. That has changed, and it can be different from jurisdiction to jurisdiction in terms of what's expected for a response time. Those kind of conditions on being eligible for standby pay are bargained, and so it might be different in Tacoma than it is in Spokane, or it might be similar. But that issue of, as the requirements on the individual become more and more, at what point does that, if any, does that become a service? Even though you're not actually called to fight a fire, you might end up working an entire shift where you don't respond to a typical, But that is the core issue. I will say, I think the time for changing it in rule is probably past. there is a general consideration that once a rule's been in place for a long time, the courts can give it sort of the same weight, and the legislature is presumed to give it the same weight as statute. That doesn't. So in this case, I think you would probably be talking about the requirement for a statutory change being the most sound way forward, legally sound way forward. Are there other questions for Ryan? All right, I think that makes Tim the big winner. Tim, just so that everybody, Tim was prepared to do the presentations on all 5 of those topics if called upon. You do not. Yeah. Right. Now, actually, I have a presentation to do, and I can't do it. I don't have the equipment to do it from up here, so I'm going to have to come around and present from there. So if you can give me just a minute to get seated and yeah, would you be willing to do that? All right, we'll teamwork this. I've got a great team. All right, let me see if I can find. I don't know if you guys will find the same humor in this that I did this morning, but as I was getting ready for the meeting, I saw a note from Tammy about a presentation that we were doing together on PTSD last week for the Firefighter Educational Conference, and that was reminded me that I was actually doing a presentation on PTSD today as well. I had completely forgotten about having written this presentation, prepared the slides, completely forgotten all about that until this morning. But here we go. There was a bill earlier this year, defining what PTSD and changing the benefits. And so I'm going to go over that briefly. The detail is in the report, which I don't have in front of me, so I'm going to be going off of memory on some of this. But one of the questions that has come up, the general purpose of this presentation is to let you guys know what benefits were already in place, how did the bill change that, what are some of the impacts of those changes, and what do we expect to see as the bill is implemented and played out. Because there has been quite a bit of maybe misunderstanding, concern about the impacts of the bill. I've had, firefighters ask me, is this going to bankrupt the plan? Concerns about what safeguards are in place to prevent members from asserting that they have PTSD when they don't. A lot of it is actually coming back to even what is PTSD. And so the psychiatric definition is found in the Manual of Statistics and Diagnostics, and the most recent one of that, DSM-5, slightly changed the definition of what causes PTSD. Historically, PTSD, post-traumatic stress disorder, had been associated with a single event, and it's the type of things that you might well expect in your profession. There would be a shooting, or there would be a fire, or there would be a mass casualty event, and during the course of the response to that, there would be an unusual amount of stress, even for you guys who have very high stress jobs to begin with. Military has done a great deal of study on the causes and treatment of PTSD during the recent years, and that's part of what has driven the discussion of this issue and the medical knowledge of the diagnosis and treatment of this issue forward. And one of the things they realized is, in addition to a single event causing PTSD, repeated exposure to the same type of event can have a similar effect. So in World War I, they might have called that shell shock. I have a nephew who was a combat medic in the desert, and he got blown up 8 times. At which point in time, which one of those events was the one that he has a harder time getting over than any of the others? It becomes very hard to distinguish in those types of situations. So the medical sciences move forward on that, and the DSM-5 talks a great deal about the types of symptoms. But one of the things, if you could advance to the next slide, one of the things that they have, those types of symptoms are outlined in detail, and they're limited. They're the kind of things that you might expect, nightmares, flashbacks, elevated stress response when you're exposed to something that's similar to the original event, like the sound of a gunshot or those types of events. PTSD claims have been allowable under workers' comp for quite some time, but they have been limited historically to the single event type of PTSD. So, for instance, if you were a police officer and you were shot in the course of your employment, L&I would treat not only the physical gunshot injuries, but also the counseling or psychological treatment associated with that event. And to the extent that that person ended up disabled and unable to return to work, that was considered a duty disability retirement. In most cases, not all, but in most cases, there was a combination of physical injury and psychological injury that L&I identified and treated. But there were rare cases where the injury was purely psychological, and L&I would treat that, provide whatever services were needed so that the member could return to work. And in the event that they were unable to return to left work, the same kind of retraining that would be done to if a person had a back injury to help prepare them for a different type of career. DRS has followed that same L&I definition as well. So if a claim was considered in the course of employment for purposes of a workers' comp treatment injury, and it ended up having an effect on a person's employment in left, then it would also be considered duty related. And so if you could hit the next slide, the types of left 2 benefits that could be affected by a PTSD related duty disability are kind of threefold. Most PTSD claims the person is able to receive treatment without it affecting their, without taking time off from work. But there are cases where they end up with time loss. And in those types of situations, similar to a back injury or any other kind of physical injury, that may also mean then that they need to restore some missing service credit. They would have what's called a leave of absence, and Left 2 provides benefits when there's a duty-related disability leave of absence. Audet, did you have a question?
No, I'm fine.
Okay. The second level of benefits in left 2, and Ellen, what if they're not able to return to work at all as a police officer or firefighter? In left 2, that's what's called a duty-related disability retirement. You get whatever benefits you've earned in left 2 up to that point in time. There's no early retirement reduction for those benefits, and there are some tax advantages to some of those benefits, but that's what you get, is what you've earned, and then you move on to another career. A third level of benefit is the catastrophic disability retirement, and this is where a person's injury is so severe that they're incapable of any gainful employment. Now, in the course of the PTSD discussions, this is one of the things. So in L&I equivalency, this would be what they call pensioning a member out. They can't retrain them. They can't get them to the point where they will be capable of any employment. In their fiscal note on this, L&I estimated that there would be no pensions as a result of this change in the 2018 law. And I think so that the same kind of thing with left 2. There would be no additional catastrophic disabilities. Part of it, again, is understanding the distinction here. This law didn't create PTSD as an allowable condition. It merely expanded it to include cases where there is multiple exposures that form the basis of it. A lot of claimants had kind of become a little bit more sophisticated anyway, to the point where, so say for instance, you were shot in the line of duty, and I met a law enforcement. This was the second time that he'd been shot, and to the extent that he raised his psychological conditions in addition to his physical injuries, this is associated with forget about the first incident. This is all associated with the second incident, and then it was treatable by L&I. So it was only claimants didn't bring up past conditions as affecting their need for treatment. As long as it was associated with a single incident, they were covered by L&I anyway. There are some expected increases in claims. Overall, for Left Plan 2, the question of how prevalent it's going to be and what is the cost, that's one of the things that I wanted to talk with you about today. Because there were a lot of different statistics about how, for instance, one study might say 20% of all active firefighters have PTSD or experience PTSD. And that gets to this question of to what degree, though? Is it to the point that it is affecting their work? Is it to the point that it requires treatment or time missed from work? And so you might see a different study saying only 3% of firefighters have made a PTSD claim or something along those lines. The L&I estimated the increase in claims from this, and OSA also incorporated into their fiscal note an increase in the number of claims. That the chart is in the report. Overall, the expected cost in the OSA fiscal note is 10 basis points. So, for instance, when I was talking to the firefighters who were concerned about this bankrupting the plan, it was like the expectation is that this will raise the cost of the plan from $8.5 5% of pay to you for you to say 8.55. So the scale of those costs, they could understand. That's obviously not something that's going to create any kind of fear of bankrupting the plan or any significant financial impacts. Another piece, working with OSA and LNI, that you will be discussing as you, one of the reasons we're discussing this is the board adopts the supplemental rate to Left Plan 2 that's required by any legislative changes. So that 10 basis point estimate by OSA is something that the board will adopt. You'll be considering that issue as you go through the rate adoption process in the next couple of months. The largest component of the 10 basis point cost, 8 of those 10 basis points, had to do with the assumption that there would be an additional 2 duty-related deaths per year. And so that was something that I talked about with OSA and with LNI and with DRS, this understanding. LNI has taken the position that if you have a suicide as a result of PTSD, and the PTSD is duty-related, then that suicide could be considered a duty-related death. That was not something that had previously been included in DRS or OSA estimates. And so that, again, is a large component of that, but there isn't a lot of historical information on that. OSA did a great job in their fiscal note of reaching outside of Washington State to find some information, and we'll be going through all of that during the course of the discussion on the supplemental rate and how that rolls into your other rate adoption. Could you hit the... All right. So that... I wasn't aware that the previous slide was the last one. These are the kind of rough edges that you get when I'm doing this. I should have rehearsed this morning. I would have if I'd remembered that I was actually doing it. But the key thing, the couple of key takeaways. One, to the extent that you hear fear from members or employers or the public that the cost of this legislative change could create concerns for the solvency of Left Plan 2, you can be reassured that it does not. I didn't talk about it in the second big takeaway is that you as a board will be considering and adopting the supplemental rate this interim. That's not something, a supplemental rate adoption is not something that you as a board have had to consider now for 5 or 6 years. So for some of you, it will be the first time through this process, and for some of you, you've gone through it before, but it's been a while. All fiscal notes where there's an impact on the rate are audited. The board's we have an external actuarial firm under contract to review these types of fiscal notes. They've already begun their work with OSA on understanding the fiscal note, and you'll get reports from them later on. The one piece I mentioned early on, but I didn't touch on, is the science about what do you do about people claiming they have PTSD, and you're not sure if they really do. There was, for some of you, this may go back to the 70s or 80s or the early days of workers' comp, but there was the same kind of concern happens on how do you tell if somebody's faking a back injury? And as time goes on and doctors become experienced in this area, there are things that you can do to distinguish between these claims. As I've mentioned, the military has done a great deal of work in the last 15 years plus regarding the diagnosis and treatment of PTSD. Part of that is determining whether or not somebody really has PTSD or perhaps some other condition or perhaps no condition at all. And there are some robust psychological tests that are out there to distinguish between who really is suffering and who is trying to give the appearance that they're suffering. So while I'm certain there will be members who will file a claim, and whether they honestly believe they qualify or not, they'll be determined that they don't have PTSD. That I wanted to let you know that there is mechanisms out there. This isn't a completely subjective thing that, and that if somebody's a really good actor, they can somehow qualify for benefits under this law that they might not have be entitled to or have earned. But with that, I went over this all kind of quickly, but with that, if you have any questions about this, we'll be talking a little bit more again about primarily the rate impact as we go forward, but some of these issues about what was in the bill. For instance, the bill created a presumption in certain circumstances that if you have PTSD, then it'll be presumed to be duty related, and but that presumption is limited to how long you've been a Left 2 member, have you had a psychological exam that's ruled out PTSD, does your employer require you to take a psych exam or not. I didn't want to get into the weeds of the actual bill today. I'd be happy to answer questions if you have those. It's more understanding the scale of the bill and how the next steps, L&I, DRS, will be going through rulemaking. Again, the general rule is if it's considered in the course of employment for L&I, it's considered duty related for Left 2. So we will see a likely increase in the number of PTSD-related temporary duty leaves of absence and perhaps even PTSD-related service retirements. There is this new category of PTSD-related service deaths that we were unaware of that we'll be learning more about in upcoming months. But again, with that, I would be happy to answer any questions that you guys have. Representative Foley?
I promise I'll shut up after this one, Steve.
No, you're good.
Some of this stuff, because I was right in the middle of it, and, which is, this is not your dad's Left 1. And that was the immediate response that we had when we started looking at this with fire, is that we're recreating Left 1, which is a completely different animal. And obviously after 7 years that either the abuses, the cost, or combination, cause a demise of Left 1 and transition into System 2 almost across the board just because of the nature of the beast. There's a very specific criteria with DSM-5. There's elements of this diagnosis, that will be determined by DRS here. So there is, as much as you become an advocate for the statistical methodology, of behavioral sciences, saying that there is as objective a criteria as you can have for each one of these elements, or a certain percentage being met by DRS, versus and on duty specifically, whether it's aggregate or single traumatic incident. That being said, Left 1 was something that was on duty or off duty. There was simply the standard was the capacity to continue employment in your present position. And it was a majority of those decisions were made by people that probably were amateurs, as you had regional or local disability boards that made this initial determination. Completely different animal out there. When I looked at this initially, there appeared to be little potential, or enough sideboards on this that at least we'd have a review, or you'd have recourse. If people tried to game the system out there because you set such a standard of criteria rather than just something that's a generic definition that they have to measure against on this. And quite frankly, as Mike and I talked about, I mean, on the floor, this is one of those things that you can have an academic or philosophical conversation about the topic, unless you spend a career on the job. Then all of a sudden it becomes personal up close and you get it. There's absolutely nobody, I mean, Jason, he presents well, he dresses well, this kind of thing. I mean, he's competent. I mean, you look at, no, I'm just saying, something, if we had a beer and we started telling war stories, it'd be a completely different scenario situation. These things do affect everybody out there. Nobody gets through this career untouched. Nobody does. And so some people handle it better than others. Some people mask it better than others. Some people don't. And I think that the standard out there, that we have yet to come up with a marquee benefit in the years we've been in existence here, which is kind of the expectation, back in when we met at Snoqualmie Pass a long time ago to put together 790, the movement towards that these are the kind of things out there that we're talking about nickels, rather than $100 bills, the cost of providing something like this. But these are starting to approach some of the things that are not esoteric and limited benefits to niches out there, members. I think this is good policy, and I think it's kind of overdue at this point, because you see some of the people out there that, whether it's military, whatever it is, that have these things that crash them. And so, as I said a long time ago, and I'll justify this with the same, a strong advocate for this, with the same mentality. We talked about medical and taking care of the families and the spouses of deceased officers. It's one of those things to where the cost shouldn't be the primary consideration on this. The value and the purpose and the attention to our members' needs, should be a primary driving force. And then we attempt to figure out, how the cost is going to work well within the system. So I wanted to touch base because I spoke on the floor for it, and I was one of the co-sponsors for it. And this is something that has been overdue, and a lot of people within our system, our brotherhood between cops and fire here, have needed this, that haven't had access to it. You got Steve. You understand, an aggregation of traumatic incidents, can be just as. Is it the first time you got shot? Is it the fourth or fifth time you had to get somebody up and tell them that the kid's been killed in a car wreck? It's just there is a value to this. So all the metrics aside, here I'm still a strong advocate for it.
We'll continue to keep you updated even after the supplemental rate as the rule adoption process goes through, and to the extent future changes or challenges come up that are identified that may require more work down the road, of course, but appreciate you sharing your point of view on this. It'll be a work in progress for a while, but there are a number of members who will benefit from it initially. LNI is trying to sort through now, how does this apply to cases that are in progress? I'm aware of at least 2 members who committed suicide, for instance, and had been diagnosed with work-related PTSD prior to their suicide, and they've been encouraged to open LNI claims. They were not aware that was even possible. Their families were not, and may or may not then qualify for different Left 2 benefits than they were originally evaluated as being eligible for. So we'll see how this all plays out. But again, like you said, this is not the type of cost that Left 1 disabilities created for that plan. There's no expectation that we'll see the same kind of impact on Left 2 as a result of this legislation. All right. Lunch is ready. We're slightly ahead of schedule. If you guys want to go ahead and grab food and get yourselves prepared for a riveting administrative update, I'll get myself psyched up to do that as well. I got my notes for that one. And then would say 15 minutes be okay? Kick back in at 11:25?
Okay.
Does that work? All right. Back in 15.
Are our folks on the phone back?
Representative Berkowitz is back.
Thank you. Ade, are you there?
Okay, if Ade rejoins us, we'll have a quorum, but even in the absence of a quorum, there's no expectation for items that the board will have to vote on for the remainder of the meeting. So I'll just dive in with the last couple topics on the agenda. The first is the administrative update. And there are a couple of things I wanted to bring to your attention. I sent all the board members an email earlier this week about a couple of personnel changes. One with the board itself. Board member Wally Laux announced his resignation. So the law enforcement community will be working on getting a replacement appointed for him. I forwarded his message to the board and to the governor on to you in his email. Also, after Paul left, I told you last month I would begin the process of finding a replacement for Paul, and the Jacob White has accepted the job. He'll start in the middle of next month. Many of you may know Jacob from his time at DRS as their legal and legislative services manager. So he brings a wealth of pension experience, and he's a great guy to work with. I enjoyed working with him while he was at DRS. He was definitely one of those candidates who didn't even know there was a job that he was interviewing, but he'd been interviewing for the job for several years, and his interviews went really well. So I didn't think it was going to be possible to lure him away from revenue, to be honest with you, but it worked out. He enjoyed he enjoyed doing pensions, and so he'll be back with us. His first day is actually the day materials are due for the May board meeting. So we were debating in the office whether or not we were going to assign something for him to present on at the May meeting. And so his first day on the job, he has to have it done. There you go. So it's not unprecedented. That's right. Welcome to the board. You're elected vice chair. That was a heck of a first day. Look at, in addition to those changes, I do want to mention the couple of outreach type activities. The Pension Funding Council Work Group meets during years where there is where it's a rate setting year for the Pension Funding Council and the Left 2 board. And the primary duty of the work group is to coordinate the outside actuarial audit of the valuations. Milliman, who has done the audit, did the last audit, will be doing this next one as well, and they've begun their work. They'll be presenting to you later on in the interim on the results of their audit. The Select Committee on Pension Policy, I also mentioned, they met earlier this month. There was some general discussion about topics of possible coordination. I mentioned the one issue we discussed earlier, the definition of child. The Department of Retirement Systems is also going to be recommending a couple of pieces of legislation which could apply to all the plans, including Left 2. They'll be here to talk about those in more detail at a later meeting, but in general, one has to do with the purchase of annuities, which is already allowed in Left 2 but is not allowed in all the other plans, and an issue called the final month of retirement payments. it's a kind of an odd circumstance right now, but when a member dies and they don't have a beneficiary designated, DRS is required to recapture a pro rata piece of that final pension. So say the member dies in the middle, the retiree dies in the middle of the month, DRS is required to go back to the estate and say, we need to get back the last 2 weeks of your pension payment. They're looking to change that so that once you receive that payment, that's it for that month. And that could apply to all the plans, including Left 2. And again, that's an issue that they'll be talking about in more detail later on, and could be an issue of coordination with the Select Committee next, during this interim and potentially the next legislative session. The quarterly budget update was included in the materials that were sent out to you. There was a modest increase in the budget. Part of it related to a supplemental budget request for additional actuarial expenses, which was approved. The allotments, though, haven't actually gone through the system yet. So on that spreadsheet that I sent out, you'll see some items in red and some in black. That'll all be sorted out by the next quarterly update. I will say, by way of follow-on to the budget update that I gave you last December, the agency is still, at this point in time, slightly overspent for the biennium. The vacancy rate from Paul's position being open and the approval of the additional actuarial expenses will pretty much make that about even. But by way of reminder, what that means is for this, as we go into the remainder of the biennium, different types of expenses that we have more control over, such as trustee education, staff education. Those are areas where we may need to say no to things that have been approved in the past in order, just as we close down the remainder of this biennium, to make sure that we are not overspent. Tim's on top of this. I'm on top of this. We will keep you up to date as things go forward. But right now, things are fine. It'll just be as some of these come up. And particularly to the extent that if we have to choose between education for new trustees or more experienced trustees, those will be all the things that'll come into play. But I will discuss that with each of you individually as things come up throughout the rest of the biennium. Let's see. Staff outreach. Tammy is not with us today because she's at an International Ombudsman Conference, and she's been recognized by her association as well. She was part of the planning commission for the conference and was actually introducing the keynote speaker. Tim attended a local financial meeting on financial wellness up in Shoreline, and I did the same thing recently up in Seattle. And then there was the firefighter educational conference last week in Spokane, and Tammy and I were jointly part of a panel speaking on the changes to the PTSD law. I didn't say anything different there than what I said today. With that, that includes the administrative update, unless you have any questions about any of it. The final item on the agenda then is the future agenda items calendar. Following your meeting last month, we took away all the different instructions that had come both at that meeting and from the prior interim, and put together sort of a rough outline of what the interim would look like for you, with all of the policy items, actuarial items, and administrative items on it. And so the paper document looks like this, if you've got that in front of you. A couple of things that are different and a couple of things that are similar that I wanted to remind you. Again, the one thing that is different is stacking the initial considerations in the educational briefings without requiring your action early in the interim. We have the rare opportunity, this interim, they haven't started in April for a while, so we've got a full interim to work. One of the things we'll do then is come back to you in July, and you'll see in bold on your July potential agenda then, decision on preliminary reports. So we'll work through with you on all of these issues, and then at that time, you'll be able to kind of keep them in context in terms of which of these 9 items do we want to work on. It may be all 9, or it may not be. Another thing that has historically happened is we tried to structure this agenda without relying on the August meeting. And again, because I think of the fact that this is a full interim, we've got an agenda where everything is covered without using August, but that will be something that you can consider in the future is do you need the August meeting, or when we get to July, you may, if you're able to cancel it at that time. At least preliminary, it looks like that. You'll see some of the things on there, the supplemental rate that we talked about early, the valuation audit from Milliman, actuarial presentations from both Ryan and from OSA on rate adoption. One thing that's also going to be somewhat the same and somewhat different from past years, as you adopt rates this year, we're going to be using the rate adoption presentations and the supplemental rate presentations all together as a backdrop for the decision on your funding method. At the strategic planning method, or at your October meeting last year and the year before, there were discussions by the board about whether to take, how to take your temporary funding method that you've been using since 2008 and make that your long-term method, what that would mean, what that would look like. So as we go through these presentations leading up to rate setting, that will be part of the backdrop is how do rates look different under each of these methods? If you adopted your current temporary method as a long-term method, how would that affect these presentations? With the understanding then that, or with the possibility then that when you adopt rates for the 1921 biennium, if you decide to change the rates you've already adopted, you could adopt your funding method at that same time, and what would that mean? If you don't adopt it, there will be opportunities to continue to work on it, but that will be more a part of the backdrop of the rate-setting discussion this year than it ever has been. The October offsite is on the agenda as historically, and then the same plan for November and December being reserved primarily for the final presentations on any legislative policy topics as you decide. And if there's any questions, the April agenda looks pretty full. Don't be misled that the May and June and July agendas are a little bit less full. The topics that are on there related to funding are going to take more time than the benefit-related topics that you got today. There were more previews, reviews of what you'd already discussed in the past. So those, especially depending on the amount of discussion that you have about the rates or about the funding method or about both, those meetings could be they could be lengthier. There's nothing, the next meeting is May 23rd. I want to bring that to your attention. Then are there any questions that you have about any of the items on the calendar? Again, these are all topics that you have put on the agenda, and we've just done our best to try to slot them in where to come up with a staff support model that makes sense for all the things that are on your plate. This was our cut at that, but it's up to you. So at the May meeting, the agenda is going to look very similar to if not identical to the May 23rd agenda that you have on there. And at that time, when there's a quorum, if you want to make changes to this, you can do at that time, and we'll have plenty of time to react and adjust to meet your needs or desires. Mike?
Thanks, Steve. For the June 20th meeting, and thanks to Representative Holey's House Bill 2709, I imagine with that going to be the effective date of June 7th, I imagine that we would need to add executive director compensation discussion on June 20th.
Make sure that there's a time for exec session on that.
And I don't know if we need a intro, I guess, for that during the May meeting. I'd leave that up to the chair and the administrative committee.
We'll make sure that there's a possibility for that, or if that's the will of the board, then that you could talk about that both in May, so that you're not coming into it cold in June. We'll have some exec sessions time blocked in May as well. Thank you for that heads up. Other questions or comments about the draft work plan? All right. See you May 23rd.